students, in the earlier class we were discussing about salient features of Indian Constitution. In continuation of that class, I am discussing now the directive principles of the state policy. Earlier I stopped that is fundamental duties of Indian Constitution, and in continuation of that I will start with the directive principles of the state policy. So, you know that directive principles of the state policy are enumerated under the 4th of Indian Constitution from article 36 to 51. So, these provisions are very similar to the or correspond to the provisions of the International Covenant on Economic, Social and Cultural Rights. Unlike fundamental rights, directive principles of the state policies are not enforceable, but we can't say that they are less important, because directive principles of the state policies are fundamental to the governance of the country. They are the guidelines, and that should be they are considered by the union and as well as the state government while framing policies or any legislations. Directive principles of the state policies lay down certain objectives like social, economic, political justice to achieve ideal true democracy. Over a period of time, many directive principles of the state policies have attained the status of fundamental rights either by way of an amendment to the Indian Constitution or by judicial interpretations. Next, coming to the characteristic feature of Indian Constitution is the Constitution is a unique blend of rigidity and flexibility. That means the constitutions are sometimes classified into flexible or rigid constitution. The flexible constitution is one in which amendment can be made rather easily as enacting ordinary laws, like how ordinary laws can be made, like Indian Constitution or any constitution can be amended. Rigid constitution means it is one in which amendment is more elaborate and as well as it is difficult compared to the making of ordinary legislation. The process of an amendment under Indian Constitution is considered both flexible and as well as rigid. That is why we are saying that it is a blender of or mixing of both rigid and flexibility of Indian Constitution. That means some of the provisions of the Indian Constitution can be amended by simple majority, like how the procedure is followed in making ordinary laws. But rest of the provisions of Indian Constitution is amended by special procedure. That means it is more difficult and as well as it is technical. That means it requires special majority. That means 2/3 of the majority of the members who are sitting and present or sitting and present in the both the houses of the parliament. In addition to that, in some circumstances, in addition to the special majority, it includes or it requires at least half of the state legislature consent. The next special characteristic of Indian Constitution is the judicial review. Judicial review played a very important role as a protector of the Indian Constitution or as a guardian of the Indian Constitution, because it protects the values of the Indian Constitution. Judicial review is a great weapon in the hands of court, which implies that means it is a limited government. That means government cannot make any arbitrary laws or any laws according to their whims and fancies. In that circumstances, judiciary through this review power, it determines the constitutionality or put it in another words unconstitutionality of those legislative acts. So, our Indian Constitution either expressly or implicitly established the doctrine of judicial review under several articles such as Article 13, Article 32, Article 131 to 136 and as well as Article 141, 226 and 227. If you get through these articles, we can know that how judiciary through this provisions have a review power. It can review the legislature enactments. Article 32 of the Constitution is very most important, without which the Constitution would not be a worthy. It is very soul of the Constitution and it is called a very heart of it. So, that means if there is no Article 32 in Indian Constitution, the Constitution is not senseless or it is not at all a worthy. Next one is independent judiciary. Independent judiciary means every judge is totally free to adjudicate the matters brought before them in accordance with their perceptions of the facts and comprehension of the laws, without any influence, without any inducement, pressure, either directly or indirectly from any angle. That is why independence of judiciary is very essential. That is why we are saying it is one of the basic characteristic of Indian Constitution. So, under the Indian Constitution, several provisions ensures the independence of the judiciary. In many cases, the Supreme Court has declared an independent judiciary is the basic structure of the Indian Constitution. In order to ensure independence and impartiality of the judiciary, the Constitution makes several provisions. That means appointment of the judges is made by the President in consultation with the judicial authorities. That means the President cannot alone or with the aid and advice of the Council of Ministers, he can't appoint the judiciary. So, he has to consult the judicial authorities in appointment of the judiciary to a Supreme Court and High Court. Security of a tenure, it is guaranteed to every judge. Once they are appointed, it is not easy, and put it in another words, it is a very difficult procedure we have to follow to remove the judges from their places. So, that is why we are saying that security of tenure, it is guaranteed under the Indian Constitution. Salaries of the judges are also paid out of consolidated fund of India. So, finally, no discussion can be made with respect to the conduct of the judges in any either house of the parliament. Next one is the universal adult suffrage. The right of the people to vote and elect their representative is called franchise. India has adopted adult franchise. Every citizen who has attained the age of 18 years has a right to vote without any kind of discrimination like sex or caste or creed or place of birth. So, anyone who attained the age of 18 years has a right to vote. Article 326 amended by Indian Constitution in 1988, it lowered the voting age from 21 years to 18 years. Through this right, a citizen can take part in the process of the formation of the government. The next one of the characteristic of Indian Constitution is the single citizenship. So, we are all Indians, we are the citizen of India. Actually, in federation, there is a double citizenship. Take for example, in USA, every citizen besides being a citizen of United States of America, he is the citizen of state in which he or she resides. Even though we are having a federal system, but we are having a single citizenship, that is, we are the citizen of India. That is the uniqueness of Indian Constitution. Next one is secularism. A secular state is neither religious nor irreligious or anti-religious. Rather, it is neutral in the matters of religion. India is a country, we know that it is having several religions, even though each individual has a fundamental right to practice, profess, propagate any religion as he likes. In India, there is no state religion, means it does not recognize any official state religion. The state-owned educational institution cannot impart any religious instructions in the classrooms. In the matters relating to the religion, the state is neutral. That means it is non-interfering. It does not promote any religion. The word secular was not present originally in the preamble. It was added by 42nd Constitutional Amendment in 1976. So, from overall discussion regarding to the secularism, we can say that state should not have any religion as its own. All the religions shall equally protected by the state. Free exercise of right to freedom of religion is the right having every citizen. State shall not discriminate against any religion. It means the state shall not prefer, favor or disfavor any particular religion vis-a-vis that of others. The last one is emergency provisions, that is under Article 352 to 360 we are having a emergency provisions. Under Article 352 it deals with national emergency. Article 356 deals with state emergency. Article 360 deals with financial emergency. As per Article 352 and 353 of Indian Constitution, this emergency power can only be exercised by the President of India, and it requires both approval of both the houses of the Parliament. These provisions make the Indian Constitution both unitary as well as federal, because in the normal times it is framed to work as a federal system, but in the time of war, though it is a federal, it designed it to work as a unitary system. That means during national emergency or even the state emergency, the whole state or nation is administered by the union government. So, that means the Indian Constitution, even though we are having a federal structure, the constitutional provision we have structured or we have framed in such a way, that means in the time of peace it is we are acted, both federal, state and as well as the provincial legislature act as a federal structure. But in the war time they are acted as a unitary structure, that means entire central government having control over the nation. The Dr. K.C. Ware has described the Indian government, it characterized as a federal state with unitary spirit. That is why we are having that even though we are having a federal structure, we are having a unitary spirit of constitutions. So, out of the discussions of all this, we can find that, we can know that what are the basic features of Indian Constitution, how Indian Constitution is unique vis-a-vis that of the other constitution in the world, like single citizenship, or maybe even though we are having a federal structure, the center is so strong, we are having a parliamentary form of a government or parliamentary form of democracy, and we are having a unique blend of rigidity and flexibility. Then we are having a preamble, it is also one of the basic feature of Indian Constitution. So, these are all basic features, they are unique characteristic features of Indian Constitution.